Good evening. So I did a podcast about 3 weeks ago regarding the application of the rape shield provisions and straight into some other issues connected with criminal justice. And towards the end of it, I extended an invitation that if anybody watching the podcast had any questions regarding any of the issues raised, or indeed any other questions in relation to criminal justice in Scotland, then I would be happy to answer them. And I'm happy to say that I have had some questions, and I'll just go through them one by one. But anybody who has any other questions in relation to these answers or anything else, please just contact me at Glasgow Advocate on Twitter is probably the easiest way to do it, or by leaving comments at the end of this video. So the first question carries straight on from the last podcast that I did, and it asks, do you support the abolition of section 274 and section 275, or just support reform? So you'll remember, if you watched the last video, and for the benefit of those who didn't, when we talk about 274 and 275, we talk about what is commonly referred to as the rape shield provisions. And I expressed a concern in that video and in other places that the rape shield provisions, although they were introduced for a perfectly proper cause, are now being interpreted in a way which could result in unfair trials and miscarriages of justice. So, perfectly valid question. Do I support its abolition, or do I support reform? Well, certainly don't support its abolition. The rape shield provisions initially were a response to a paper by the Scottish Law Commission back in 1985. And although under the common law of Scotland, so that's the law as it had developed by case law, it was not permissible to challenge or to bring in evidence which affected the character of the person making the complaint, and it wasn't permissible to ask a complainer in a rape case about sex on other occasions with the accused, or sex on other occasions with other men. The Law Commission expressed the opinion that those rules were being ignored, and I don't have any doubt whatsoever, and I've said this publicly, knowing some of the personalities who were practicing in the High Court in the 80s and even in the 90s, it would be no surprise if these rules were being essentially ignored, and that women were being exposed to a fairly difficult experience in breach of the rules which operated. So, to make things clear, the Law Commission brought in section 274 and 275, and what was prohibited was essentially challenging the complainer about character and sexual matters. And I don't recall a single legal professional in Scotland having any difficulty with that. So certainly, if we went back to the pre-2002 position, then I would be in support of that 100%. I could even be persuaded to add to the prohibitions which were enforced pre-2002, although that would take a more detailed discussion, more detailed than I can really have on this video tonight. But, I do accept that it's proper that there should be rules on the questions which lawyers should be allowed to ask in these very, very sensitive cases. So I don't support the abolition of the rules. Reform is quite a difficult subject because it is a statutory provision, and there's absolutely no appetite in the Scottish Government to change it. In fact, there were proposals only last week, sometime 10th, 11th September 2025, to extend the rape shield provisions. I don't think the extensions really make a huge difference, but clearly the direction of travel at the moment in government is to tighten the measures rather than relax them. So don't really see any prospect of any reform, but I maintain my position that I think the pendulum has swung too far in restricting the questions that can be asked and the accused and the evidence that the accused can give in relation to these trials. Second question, do you believe that the Moorov Doctrine remains an essential part of Scots law in prosecuting sexual offences, or do you believe it should be abolished? Now, some people may not know what the Moorov Doctrine is. In some cases, in fact in many sex cases, the accused has had more than one victim, and all the victims are permitted to give evidence in the same trial, and at the end of the evidence, when the jury are about to retire to deliberate, they're given legal directions, and they're told that if they take the view that the various witnesses are credible, the complainers are credible, and they speak of conduct which has similarities in time and place and circumstance, then they can apply the Moorov Doctrine. And sometimes the easiest way to explain it is that if a sex offence takes place when only the accused and the complainer are present, and Scots law requires a second source of evidence, then the question might be asked, well, how can there be a second source of evidence when there were only two people present? Well, the Moorov Doctrine sometimes gives the answer to that question, because if there is a second victim who identifies the accused and speaks of similar sorts of conduct, then that evidence, if believed, can be used to support it. So that's what it is. Do I think that it should be abolished? Absolutely not. I don't see anything illegitimate with it being used in that way. Of course, it's perfect common sense that people who will commit sexual offences against children are likely to do it when only the child is present. It's unlikely they will do it in the presence of eyewitnesses, and therefore it makes perfect sense to me that evidence of this type should be permitted. The people who oppose it and think that it should be abolished, I suspect the argument is it's quite easy for two people to get their heads together and, put a story together, and if they're both believed on that story, then obviously an injustice will result if the story's been made up in the first place. Now, obviously, that is a concern, but sadly it's a concern whatever type of eyewitness-based evidence you're considering, because, in an assault charge, it could be the position that no assault had ever happened, and two people get their heads together to say that they both saw the assault. They were both present at the time when the assault took place. And, only, I think the young woman's name was Ellie Williams, who was convicted of making false allegations, a young woman from Barrow. There was a TV documentary made in relation to her. And of course in England, they don't have the same rule in relation to corroboration that we have, but she claimed that she had been physically injured in one of the attacks. There had been no attacks, she'd made it all up. And to support her evidence that she had been physically attacked, she hit herself with a hammer, causing quite a severe injury to her head. So if people are prepared to go to those lengths, then it may be there is no criminal justice system that can guard against that happening. All that can be hoped is that by proper investigation and the defence being allowed to properly cross-examine, that injustices can be prevented. But if we had to abolish an evidential doctrine on the basis that things could go wrong if it was adopted, it would be pretty difficult to see any form of evidence which would ever be admissible, with the result that a lot of guilty people would go free. The third question, and the last question which I propose to discuss tonight, is do you believe that trials should only do you believe that rape trials should only conclude on the basis of a unanimous verdict? I don't, but I think in Scotland there is a problem in the sense that, as far as I know, Scotland is the only country in the world where you can be convicted on a simple majority. So if you're charged with murder in Scotland and there are 15 jurors, if 8 jurors think that you're guilty or that it's been proved beyond reasonable doubt that you're guilty, and 7 think that you're not guilty or that the charge hasn't been proven, then you can go off to prison for 25 years essentially on a single vote. Now, I've always been opposed to that. You know, in trials we talk about the jury as a single body, as a unit, as a organisation, and therefore if a single body, if 8 members of a single body have if 7 members of a body of 15 believe that there's a reasonable doubt about guilt, then that sounds to me like the body as a whole has a reasonable doubt. And I sometimes put the matter this way: if you were taking a decision of importance in the conduct of your own lives, maybe leaving a job that you liked to go to a job where you'd been promised the moon, if you could distill that decision into 15 questions and the answer to 7 of those questions was no, then most people would preserve the status quo. Most people wouldn't make that big decision if 7 out of 15 questions were answered in a way that suggested it was a bad idea. So it's extraordinary to me that people in Scotland are convicted or can be convicted 8-7 on very serious charges. I speak of murder, but the question was about rape trials, and we know the consequences for an accused who is convicted of rape. There'll be a sentence of somewhere between 6 and 12 years imprisonment. There'll be a lifetime on the sex offenders register. There will be a difficulty obtaining contact with any children or other young members of the family. So very, very drastic consequences, and the idea that you should face those consequences on a vote of 8-7 seems to me wrong. I think the Scottish Government accept that now. There's a downside in that the not proven verdict is to be abolished. I think I'll do a podcast about that soon. But I think if we do away with the not proven verdict, which seems likely, then we will move to a system where there has to be 10 out of 15 in favour of a conviction before a conviction can follow. But that's still been debated in Parliament, so we'll just have to wait and see how they end up with that. The other question, supplementary question to the last one, was to do with transparency around the verdict. And I think the question was, should we know the numbers? Because at the moment, all the accused is told is that it's a majority verdict. The accused isn't told if it's 8-7 or 10-5 or 14-1. So should there be transparency? I've never understood why there shouldn't be. I think possibly historically we weren't told the majority to protect the jury, but I mean you wouldn't know which members of the jury had voted which way. And you know, recently I've been involved in quite a few trials where it was a unanimous verdict, and of course when it's a unanimous verdict, then the accused knows that every member of the jury has voted against him, essentially has voted for conviction. So it does seem a strange distinction to me. It's never something that's struck me as particularly important, but given the question has been asked, I don't see any reason why the majority shouldn't be disclosed. But there's no support for that suggestion. It's not in the current bill, and I don't see any means in the reasonably near future for that position to be changed. So hopefully I've answered all the questions which have been asked. If anybody has any other questions, as I say, send a message to me on Twitter at Glasgow Advocate, or put something in the comment section on the YouTube channel. either of those things will be satisfactory, and I'm quite happy to come back on at a future date and answer the questions. I have been writing tonight about the not proven verdict, which has taken me quite a long time. So I think I will probably come on and make some use of that, the effort that I've put into that, by talking about it at some stage soon. So look out for that. And if there's anything else on the criminal justice front that you would like me to cover, then please just get in touch and we'll do that. My wee remote control doesn't seem to be working, so you'll have to excuse me reaching towards the phone to turn the camera off. So good night. Thanks very much.